Good afternoon, everybody. My name is Steve Cushman. I'm the president of the Shoreline Elder Care Alliance, and with the library, I'm happy to bring to you our educational experience about all about elder care law. The Shoreline Elder Care Alliance is a group of senior-oriented businesses that help seniors navigate through the aging process. Our big event's coming up in September. You'll see advertising going out for that next week. Every year we do a celebration of healthy aging. It's held at Woodwinds. It's completely free. There's no charge to anybody. And you can get your tickets online or at my office or Downtown Medical. It's a full day. We have exhibitors. We have interactive stuff. We have an entertainer. We have music. We have all full lunch and a really good keynote speaker. It's going to be Dr. I forget his name, Mazzucato, I think. He's the head of the Adler Clinic, so he should be a pretty good speaker this year. So I'm going to introduce you to Pam. Pam is our, she coordinated this event. She's going to introduce our speaker and we'll get going. Thank you.
Hi, everybody. I'm also on the board of the Shoreline Elder Care Alliance. My name is Pam Kirkby, and I'm a senior. Sorry? Can you hear me now? Okay. My name is Pam Kirkby, and I'm a seniors real estate specialist. I'd like to introduce our speaker, Stephen Rubin. Attorney Rubin was born in New Haven and graduated from Cheshire High School and the University of Connecticut. He later attended Widener University School of Law in Pennsylvania. While Steve was in law school, his mother was diagnosed with ALS, commonly known as Lou Gehrig's disease, and given less than 6 months to live. He was thrust into a number of roles that his clients often find themselves in: caregiver, advocate, provider, and concerned loved one. Seeing how his mother's belief that her son could make a difference had helped her live almost 3 years, his own passion for the law increased. Today, he helps his clients deal with tough issues such as death, incapacity, disability, special needs, Social Security, asset protection, neurodiversity, and taxes, and provides assistance in the best and least stressful way possible. With that, we give you Stephen Rubin.
First, we're going to have our first intermission.
Yes.
All right, try that.
So good afternoon. Everyone hear me? Perfect. Asia don't even need a microphone. So we're going to talk about what is elder law and really, what is it? What do we think elder law is? Because it's got a really terrible name. Because everyone thinks it's just for the elderly. It's not. Elder law is actually a branch that started in the 80s, and it originated with people who were aging and needed long-term care and had other issues. But it's now kind of been thrust on its head because elder law went from one area of law to now 27 areas to get certified in. Elder law encompasses things like Medicare, Medicaid, but also special needs planning, long-term care planning, disability. It's really about control at the end of the day. It's really about maintaining our control and figuring out what we want to have happen to us. So, a lot of, I like quotes from people sometimes, but I like this quote from Warren Buffett, because a lot of planning is really about how we want to envision things for ourselves and for our loved ones when we pass. And we're going to talk a lot about that. But planning is not just about death. A lot of planning is about life. And that's why we have to go through that broader spectrum of it, because I have an estate plan. I have an elder care plan. I don't think I'm old, although my niece told me this morning I am. She told me I had gray hair. So that was lovely. She's 5. She may make it to 6 even. So there's a lot of differences between what elder law attorneys do and just traditional estate planning, because a lot of it focuses on the care aspect. We look at care first. How do we find, get, and pay for care? It's the most expensive thing most of us will ever face in our life. And the care averages have gone up over and over and over again. And Connecticut is no exception to the rule. We have seen significant increases in the state. Anyone want to guess what 1 month on average care is costing in a nursing home now statewide?
Yeah, approximately 15,000.
Approximately 15,000. That's the state number. How about the actual numbers that the state doesn't publish?
That's at
16, 15. So we're seeing averages in anywhere from 15 to 20,000 now. I just got my first 22,000 today. So the rates have gone up significantly for what a bed is going to cost. And I don't see it stopping anytime soon. And neither does the state, which is why we're now trying to get people to stay home more. We don't want you to go to a nursing home. We want you to stay home with care. So that's what the elder law attorneys look at. We look at how do we stay home? You know, what adjustments do we need to make to the house? Where do we have to live for care? There's all different things that elder law focuses on that just isn't with a regular estate planning, and that's kind of what we do. But when we do these types of plans, you know, we have to start thinking about what do we want to have happen? You know, our goals and our needs. And that's always a hard part. Because everyone comes in and says, I need a will. Maybe. What you need is a plan. But what is your goal? What do you want to have happen? My plan is going to be very different than yours because the things I care about are different. Also, the things that I'll put in my documents are different than what the average person does. Not because my documents are, you know, special, other than the fact that I'm just special. So I want to make them unique to me and what I'm trying to do. Because my documents are a set of instructions for my lifetime and my passing. It's really simple. Because estate planning isn't one thing. You know, when people hear about estate planning, what do you think of? Title 19. What else? Those people tell me they think of death. Their assets. Yeah, title 19, estate planning is really about lifetime. It's about lifetime use. I care what happens to my money more today while I'm alive. I'll still have a plan for while I'm gone, but while I'm alive, don't I want to control how it's used? Even if I can't be in control of it, I want to control it. I want to make sure that I have those powers, that I can do it. And that's one of the things that estate planning gives us the power of, is we get to stay in control. We get to maintain that control. We get to utilize that control. And that's where the creativity side comes in. You know, whether it's doing a will, which is, by the way, the least important document of your estate plan at this point. Anyone know why it's the least important document to have? There you go. Because it's only valid when you're dead. I get calls all the time from people. Oh, my mom's executor. Okay. Is mom alive? Because if so, you're nothing. You have no power to act just because you're named in a will for when she's gone. The will is the least important document because it only matters when we're gone. Because that's why planning is important, because we got to focus on the lifetime. Because what happens if we don't plan? Could run out of money. I see it all the time. Sometimes it's intentional, but a lot of times it's accidental. We can lose our home, or our house can be unprotected for our kids. There's a big risk of health. You know, there's been some really interesting studies about family caregivers and what the burden does to them. I've now done it twice. Family caregivers are, in this country, we estimate that their value is over $70 billion a year worth of care. That's the current estimate. Unpaid care for most of it. Yeah, it's a huge economic burden. How does it impact their lives? You know, statistically, what we've seen, higher risk of bankruptcy if we are a caregiver for a parent, higher risk of not getting a promotion at work or losing our job, more medical problems of our own to deal with as we get older because we don't take care of ourselves. And we see similar things happening with spouses. You know, we see like dynamic change. We had a case where a husband and wife, and the wife had become a caregiver for him over a period of time, and their dynamic was not of husband and wife anymore. It was patient and nurse. And they would fight over a lot of little things, and the relationship was terrible. They couldn't hang out anymore. They couldn't watch TV together without arguing. By getting just a little bit of care, and it helped switch the dynamic back. because it took her stress level down, which took his stress level down. And at the end of the day, both ended up happier again. So planning isn't just about looking at numbers or having a will. It's about making sure everything works together, because we don't want strangers. We don't want courts. We don't want other people making our decisions for us. We want to make our decisions for ourselves. And, one of the things I was asked about talking about today is, Medicare and Medicaid. I don't want to spend a lot of time on it because it's boring, but the big difference is what it pays for. Medicare is health insurance. It is an HMO. It does not cover long-term care costs, period. It doesn't pay for you to go to a nursing home. It doesn't really pay for care at home. I do know that there's been a lot of talking around that there's 32 hours of care available under Medicare rules. That's technically true. However, it never happens. And it happens so little, in fact, that there was a lawsuit filed against CMS recently for not giving people the 32 hours. And you know what the judge said? They don't have to. They don't have to give you those 32 hours. It's not required. So if they give you 2 or 3 hours at most, that's all you're going to get. So you're not going to get long-term care out of Medicare. Medicaid was originally set up as a health insurance program. It's actually was one of its biggest uses was health insurance in the past. What has happened over time is that the biggest expansion has been for long-term care. 88% of all Connecticut residents in nursing homes are on long-term care Medicaid. 88%. Which also answers one of the most common questions I get. Do I get the same care at the facility if I'm on Medicaid or not? Yeah, because pretty much everyone is. They don't go around marking your rooms with a star or any sticker or anything to tell people which one provides Medicare and which one's private pay. They don't care. The staff doesn't care. Everything's the same. So because Medicare is not going to cover long-term care costs, that's where Medicaid has generally been kicking in. Medicaid is not a program. There's a common myth that it's just one thing, and it's not. When it started, it was really designed to be one program, but it has grown, and there's a number of different programs with different sets of rules and different coverages that can be based on age, assets, care levels. There's a lot of different rules for it. On its basic level, though, Connecticut follows an old rule that the asset cap is $1,600 for almost every beneficiary of Medicaid. That's assets, not income. There is an income cap, but that's different. So we have to plan for that because no one wants to spend all their assets down. No one wants to lose all their money. And that's what planning gives us. And that's what elder law is about. So we're going to start talking about some documents that we all need and some things that we should have. And the things I think are the most important things of an estate plan. What do you think is the most important document in your estate plan? Power of attorney. Okay. What else?
Trust your attention.
Trust could be important, but it's not the most important. Healthcare directives. Maintaining control over our healthcare decisions during incapacity. By the way, when I said I have abnormal documents, that is actually in my advanced directive right now. It also tells me when the hospital reads it. Because it says if I'm on life support, unplug me and plug me back in, then see if it works. Why not? It works on my computer. So we have to talk about who's going to make our decisions for us, who can handle it. And that it's a big thing. We saw this throughout COVID that most of Connecticut doesn't have an advanced directive. There's something over 60% of the residents of the state have never done one. And of those that are in existence, many of them are outdated. And outdated doesn't just mean a law change. How about, oh, I don't talk to that person anymore. Or, oh my God, they passed away. Or they're sick themselves. We see a lot of that stuff where it ends up leading to longer period of care that is unnecessary or going to court. And that's one of the things we have to think about with the advanced directive is who we're going to name and how we're going to name them. And the advanced directive history is kind of interesting. I had someone recently who just told me the advanced directive comes from Terry Schiavo and the case in Florida years ago. I'm sure everyone heard of it. If y'all recall it, It's a young woman who had had a stroke and was either in a persistent vegetative state or not, depending which side of the court case you want to listen to. And people think that's why we have advanced directives now. That's not it at all. In fact, that case wasn't even the first of its kind. We had cases like that going back to the 50s in Connecticut that have been reported. In 1952, there's a Connecticut case, and it was a young man who was a football player, and his parents were having an argument because he was injured at school in a game, and his parents couldn't decide if they should turn off life support. Dad wanted to, mom didn't. Doctors thought he was brain dead. And the parents couldn't figure out who should be in charge and who was responsible. And believe it or not, there was no law on the books for this. It didn't exist. So the parents went to court, and it went all the way up to the Connecticut Supreme Court before we got our first ruling. And then we had multiple cases after that. In fact, it wasn't until 1992 that the advanced directive and the living will even came to be, because that took all 50 states. That's when we finally all started to adopt it. It started in California. It spread across the country very slowly. But that's how they even came to existence. And now we have these documents that let us stay in control because we get to make our decisions for us. And the first step is to identify who they are. Who's going to make your healthcare decisions for you? Now, I get a lot of different answers on this when I ask that question. Yeah. Half the people tell me, oh, I want my oldest child. There are a bunch of people who tell me they want the closest one. Some will tell me they want the one that understands medicine the most. Some will tell me they want all their kids to do it, which no, that's never going to work. My answer is don't pick the closest child. Don't pick the oldest child. Don't pick the smartest or the one who knows the most about medicine. Pick the kid who fought with you at the dinner table every night. Pick the kid that constantly would pick a fight and would stand up for what they believed in. Because you want the person who's going to be named here to fight for you. And medicine today has become a fight every time. I just went through this with my dad. 3 days before Thanksgiving, I had to drive him to the ER. And he needed surgery. So we're sitting in the ER and everyone knows he needs surgery. And we had a visit from the general surgery team who said, nope, this isn't us. This has to go to neuro. And then we had a visit from the neuro team who said, nope, this has to go to vascular. Then we had a visit from the vascular surgery team who said, oh no, this should have gone to neuro. Yeah, that was fun. So we kind of just dealt with this, and we've been there for, I don't know, 7-8 hours. And meanwhile, it's just getting worse. He's feeling worse, and we're waiting for anybody to make a decision. Well, I'm his healthcare directive. I'm the person who's in charge of his decision-making. And I like a good fight. So I started calling the chief of surgery's office. Turns out he's on vacation. That didn't matter to me. I kept calling his office anyway until they would page him. Then I would page the chief of every one of those 3 departments. And I kept paging them nonstop. I would call each of their offices, and I set up a system where every 5 minutes they were getting a call. Believe it or not, that works really well. They all came down, and shockingly, all around the same time. And I closed the door to the room we were in, and I said, hey, I'm not letting you all leave until there's a damn decision made. You want the fighter. You want that kid who was always in trouble at the dinner table, which does happen to also be me, because you need someone who's willing to fight. There can't be white coat syndrome. There's this theory that people get very respectful around doctors. You can be respectful and still be willing to argue. And there's a big difference. Respectful doesn't mean I'm going to listen to everything you tell me and follow it. You have to be ready to fight for your parent or a family member, whether it's a spouse. And that's who we name. We name the fighters. If they'll respect your wishes and they'll fight for your wishes, that's who we name. I don't care about their knowledge of medicine. I don't care how close they are. I like the person who argues because I don't even agree with the statute. The statute in Connecticut says you're a healthcare representative. No, you're not. You're a healthcare advocate, because your job is to be an advocate for your parent or your loved one, whether they're in a hospital, a nursing home, home care. It does not matter. You have to advocate for someone, because otherwise you don't get proper care. And the reality is the squeaky wheel is going to get more attention. It's also why if someone goes into a facility, we vary visit times. I never visited him in rehab the same exact time anywhere. I would go at different times of the day because I made sure I hit the different shifts. It's important to make sure we get those levels and we get that care going because it avoids delay by having those things set up. And it can be a permanent trait, right? Or a temporary one. You know, I had surgery last year. There was a few days where I wasn't making decisions, or apparently I had conversations with people that I don't recall. You know, because unfortunately I was in the hospital, I was on pain meds. So I had an advance directive. I had someone there to be my representative and to make sure that my wishes would be followed. And beyond just having the document, one thing I find that all of us avoid is having the talk. Having that talk as a family, sitting down and discussing what the issues are, what the risks are, what the concerns are. Because it gets very difficult to do. We don't want to think we might get sick and die. The reason I think the talk has become so important is it's for all of the family members. It's not just for the person named, it's for the others. Because we'll tend to see a lot of arguing amongst siblings now over a decision that was probably what mom or dad wanted, but because of whatever reason, it didn't get into the system or they didn't know. So I'm a big proponent of making sure those things are clear. Yes, ma'am. Now, the second most important document in our plan is the power of attorney. A power of attorney is strictly a financial document in Connecticut. There's this big myth that you can combine them into one. That does not work in this state. You can move to Rhode Island for that, but you can't do it here. And most states are getting away from this. And there's a number of reasons why, most of them very good. Like, do I really want the person making my medical decisions also being in charge of my money? Or maybe I want multiple people to help with financial management when medical, I'm only going to have one. There's a whole lot of reasons we split them up, but it works well and it was a good idea. So who makes decisions for us financially if we can't? Your spouse can't just do it. They don't have automatic access to things. As a spouse, you have no right to access a retirement account or a 401k or a life insurance policy. There has to be somebody named to act on your behalf financially. So we need to have this power of attorney. But the thing with the power of attorney is it's not just about having a power of attorney. A lot of times people come in and go, I have a power of attorney. You know, is it valid? Well, that's a really good first question. Is the power of attorney valid? But the next question is the power of attorney any good? Because powers of attorney are only as good as the powers that are in them. And the way Connecticut has set it up, and the way almost every state has now set this up, is the powers are designed to be customized to fit our situation, our goals, what we're trying to accomplish. No two power of attorneys look alike as a result. The mere basic forms that the state provides are basically just that. They exist so you have something, but it doesn't mean it does anything. And I have a lot of examples of that, but let's pick a really common one that I see all the time. Let's say there's real estate and both spouses own the real estate. And one of them goes into a nursing home, so we want to put the house into the other one's name. Can we do that with a power of attorney? No. See if you knows. Any yeses? See some yeses? All right, it's a trick question. The answer is it depends. Because we need powers. It's not just having the document. We have to have special powers in here that allow for it. So there's a few common ones we need. The first one is pretty obvious. It's real estate powers, right? I mean, it's a house. So we're going to transfer real estate. We need to have real estate powers. But is that transfer of the property, is that a gift? No. Yes. A gift is legally defined, and yeah, lawyers are boring because we define gifts, but a gift is legally the transfer of an asset from one person to another for less than its market value. That's what a gift is. It's most basic level. So it's a gift. Well, now we got a problem because in Connecticut, we generally limit gifts to the annual exclusion amount, which is $17,000. Now, I hope half of my house is worth more than $17,000. But that's a problem then, because if it is, well, now I can't transfer it unless I put in waivers that allow the gifts to be done in excess of the state statute, which can be done when the documents are drafted. Then we have another issue that lines up. And one of the issues that comes up with the power of attorney is, the person we name on it, they're a fiduciary. They're not supposed to use the assets to benefit themselves in any way. What happens if it's the spouse who's the agent? If they're the ones who are supposed to, are one signing it? Can they do that? Is that a violation of their duty? Yes, but it's also a waivable one. And that's what comes in when we draft. That's why they're supposed to customize, because they have to fit that situation. I've done powers of attorney that are as short as a page, and I've done them as long as 40 pages, because it depends on what we're trying to accomplish and what the goals are and what we need to do. That's the key with the power of attorney. It's not just about having one, it's having a good one. Having a bad one is just as bad as not having one at all, because you end up in the exact same spot. Conservatorship. Conservator is when a court appoints somebody to act for our behalf, whether it's as a financial conservator or a conservator of the person where they're just making medical decisions. But either way, it's court ordered. And there's a big thing that we lack in conservatorships: dignity. It is not dignified. Now, I don't know about you all, but I really don't feel like having my family go to court and have a public hearing where they are out their dirty laundry. I don't need them fighting for the general public's amusement. They already fight for mine. So I want to limit those things and eliminate it. And by having the document and making sure it works, I do that. So conservatorships are just an added expense, they're added time, and they're just not necessary. And that's why we have to do the power of attorney. Now, in Connecticut, there's generally going to be different types of powers of attorney that are recognized. A durable power of attorney is one that's active today. So I sign it today. The person I name has the power to act, and they have this power to act until I revoke it. Either I revoke it in writing or I revoke it by death. The other very common type is what's called a springing power of attorney. So a springing power of attorney is one in which the people we name have no power to act. But the theory goes they spring into action as soon as I've lost capacity to act. It sounds like a really cool thing, right? Hey, these people have no power. We don't have to worry about them. And they can't do anything until we're incapacitated. So we don't have to worry they're going to take any of our money. Unfortunately, it's been banned by statute in a number of states because it turned out it was higher abuse than anything else. Why? Well, just because of that. They didn't have access to your money until you couldn't monitor it. Now you can't monitor anything and they have access to all of your money. That became a big problem. So Florida has now banned them entirely, whether it's a Florida version or a Connecticut one, they will not use it in their state. Other states have now started to follow suit. So there's a risk, and the main reason people always did it is they didn't put someone on their documents because they didn't trust them. If I don't trust somebody, why am I going to trust them more when I can't monitor anything they're doing than when I can? As a rule of thumb, we don't name people we can't trust. I mean, really trust, because most of the cases we hear on TV, most of the cases that are on the news all the time, we've all seen the power of attorney theft cases, right? I mean, it's all over the news. It's a great story. The stories about them actually working never occur because, well, that's not sexy. A lot of those cases, you could see that coming. The issues were pretty visible. The nosy neighbor downstairs who saw your health wasn't doing too good, or down the street, and they go, I'll be your power of attorney. Give me the power. I'll pay your bills. And then you're shocked that they stole money from you. I'm not shocked. I like my neighbor. I'm not giving them access to my bank accounts. A lot of those things come up constantly. And we have to be prepared and vigilant. And that's where drafting it well and thinking about those things work. Sometimes it's what we call the several powers, where we name multiple people. So if we are going to have someone doing it, we have multiple people who can watch the account at the same time. Sometimes it's going with a professional where there's monitoring and they have a duty to us. There's all different variables and options that are out there, but not having, just naming someone we don't trust or don't fully trust is not one of them. They say you never plan to fail. I disagree because I know that's a plan for failure because I've seen it time and time again. Yeah, and I've had cases where that's happened. I had a client who he did documents a few years ago with another attorney, and he named his niece on them. He said, she's young. I don't really know that she was, I should have named her, but I knew at the time I shouldn't have named her. And I could have named her parents or anyone else, but well, she volunteered. I figured, she's young. She'll be around a while. $700,000 later, she's no longer around and she bought a house in Florida with the money. So those are why we don't name people we know we shouldn't be trusting, because it's going to lead to a problem. And that's a family member. Is he going to put her in jail? Yeah, he doesn't really want to. Could he? Yeah. But we see that a lot, where people, we don't think about those things. So it's time to start thinking about who we really trust and how we trust them, and before we empower them. Sometimes it's the kids, sometimes it's another family member, but it has to be somebody we really trust. So one of the things that I really like, and this is probably my favorite planning document of anything we'll talk about, is a trust. I like trust because trusts are the most flexible tool in planning. They give us the most options. They give us the most power. There's so many things we can do with a trust that I can't do with anything else. Now, a power of attorney advance directive only works during our lifetime. A will only works when we're gone. A trust does both. It's the only document that can exist for us at life and at death. That's one of the things that makes it so cool. So what is a trust? On its most basic level, we've all created a trust before. Has anyone ever had a friend or a relative or done it themselves where, you give someone a gift and you say, hey, look, this is for my significant other, my friend, my child. I don't want to risk them finding it in my house. Can you hang on to this for a little while for me? I'll come get it. That's actually a trust. That is what a trust is. A trust is an agreement on its basic level to hold property for somebody. That's what a trust is. They're created all day, every day, and we don't even realize we're doing it. A living trust or a revocable trust is just a larger degree of that, where we have something where somebody's known as a grantor. So I created my own trust. I'm the grantor, and someone who's known as a trustee who's in charge of the trust. In my case, I'm also in charge of my trust right now. I'm the trustee. And we have a beneficiary. And guess what? I'm also that beneficiary. Because during my lifetime, I'm my own beneficiary. That's how I created a trust. And I fund my trust. I move assets into it because I move in anything I own. I can move in pretty much everything I have. I can move in my house. I can move in my bank accounts. I can move in my investments. The only thing I can't move in is my IRA and my 401k, because the IRS will smack you for it. So it's a big plus in that I can maneuver a lot of things very quickly. Now, trust also let me get really creative. So not only does it work during my lifetime, but I can get really creative with how it's going to work when I'm gone. How do most distributions happen? What do we think? It's outright, right? You give someone money, they walk away with it, and that's it. That's what everyone thinks happens at the end of the day. But trust let us play with that. We don't have to do it. So we're going to go back. We're going to use my trust for a little while. So in my trust, I leave money to my niece. I probably should change that, but for the time being, she's still going to get it. If she gives me one more old joke, though, all bets are off. She's lucky she's cute. So I'm going to leave her money. Now, I don't think she's ready for it. If something happened to me tomorrow, she's definitely not ready to manage money. But I don't actually think she's going to be ready to do it at 18 either. Because what's to say at 18, she's all of a sudden ready to receive and hold funds and she's going to understand its value? She won't. People generally don't understand the value of money until they get a little older in life. I don't want her to just get it then. So I've set up provisions in my trust that say she doesn't have access to the money until she's 25. And I picked 25 for a number of reasons. One, I wanted her to have a chance to get through school and actually have a chance to start life. I don't want her to just get it right away because I don't want to destroy her. And one of the things I've learned doing this for a while now is if we give someone a really large amount of money at a young age, we damage them. We hurt their growth. They don't understand how to earn a living. They don't understand how hard it is or the challenge of owning a business or running something or creating anything. We end up in a situation where they just live off of what their inheritance is or think they can anyway until they blow it. It's also why I don't pay for college education. I don't think college should be paid for out of a trust. I will pay for loans. If the kid goes and gets a loans and they actually graduate, yeah, okay, use the money to pay the loan back. But I don't give them money up front for college. And I learned that because I had a client who did. And he paid for his grandson's college education. And every year he was writing a check out for $45,000. His grandson partied through 4 years of school, didn't graduate at the end of the day because he didn't have enough credits. No, get the loan. You own that money. You have a responsibility for paying it back. You're going to pay a lot more attention in school. Then if we just pay him off, we're just doing a nice thing, but he's actually had to earn something. So we can set those things up in trust. So in her case, at 25, she's not getting all the money either. Because I want to make sure she knows things. Because one thing school does not teach these days, finance. How many people learned about retirement accounts in school? Investments. They don't talk about IRAs and 401ks and how you save for your future. So what I'm doing is at 25, she actually becomes a co-manager of the money with somebody else. And that person is going to be required to take her, and this gets my sisters, they're going to go and she has to participate in the meetings with the financial advisor. And she's going to learn about investments and she's going to learn about return on investments and portfolio management and retirement benefits. And at 30, eventually it'll all be turned over to her. But those 5 years, she's going to be forced to learn things that she will never have learned otherwise. Because I hear time and time again from clients, there's no financial maturity. I had a woman in Friday who said, my daughter's 37 years old. She can't handle this much money. She doesn't know what to do with it. She's 37 and she's not going to know how to handle an investment account. Well, I'm making sure she's going to know how, and I'm doing it through my trust. Because one of the things that we often hear about is legacy. How many people have heard you got to pass on your legacy? Pretty much everyone, right? What's a legacy? What's your legacy? How many people think it's money? Raise your hand. That's right. My mom's legacy when she passed wasn't money. It was lessons. It was how we treat people and how we act. It was family and our relationships with each other. It was how we did things. That's the legacy. Whether we got $1 or $1 million, it wouldn't have changed the legacy. The legacy is more than just dollars. And most people confuse that and think, oh, I got to save every penny for my kids. No, you don't. You have to teach them lessons because we never stop learning and we never stop teaching. It's how they treat things. So the trust lets me do that in a legal standpoint. So I just had a client, we just did this last week. We set up a vacation trust. In her trust agreement, we set aside money. And it requires that the family members who are going to be named go on vacation together once a year. And we're setting aside a budget and we're figuring out how much we're going to put in here. And she's had some recommendations for vacation sites they can go to. And each year they're going to have to do it. If they don't go on vacation, the money's not going to them in any other way. It'll all go to charity. She's forcing them to use it for vacations because she knows that they don't all get along all the time. And siblings fight. Everyone says, oh, it's don't be my kids. Yes, it will. My sister's my best friend. She's also the person I'm most likely to go to jail for murdering. So, there's things that exist in the sibling world. Well, when my mom passed, one of the things she required of us is every year we had to get together. Every single year, we have to at least have one time where we get together and we go on a trip. She didn't put money aside for us, but she required the same thing. Wasn't a legal requirement. We just felt we had to do it. Not everyone does it that way. So we set up this vacation trust and now they'll go and they'll get to celebrate and they'll get to do things and hopefully they'll get a real good relationship out of it. We're also going to set up a charitable share. And this is different because everyone hears, oh, I should donate money to charity. Which charity? And how often? So what this is going to require is this is actually for all the grandkids, not the kids. And the grandkids get together once a year and they get to vote on charities that are going to get a distribution. And they're going to get to pick them. Why? Because she wants to teach them that being charitable is a good thing. So yes, they're going to get some funds and yes, there's going to be money for them, but there's more than money in this trust. There's lessons, there's teaching about treatment, there's teaching how we do things. Trusts let you do that. I can't do that in any other document that exists other than a trust. But I can set just those things up. So we get to be really creative with our funds when we pass away. We get to really figure out how we want them to operate. You know, whether it's a share, like I have stuff in my trust going to my dog because she's my responsibility. You know, if I pass away, she has vet bills still. She needs food. There are expenses related to her. So I'm making sure she will be taken care of. There will be someone who manages money for her. Yeah, that's not an abnormal thing. It happens a lot. And in a lot of cases, people don't consider what happens to the pet. Well, I don't want her going to a shelter. She's not a shelter dog. It's not where she's going to end up. But I've arranged for caregivers and I've arranged for services for her to make sure she gets what she needs. That's part of my plan. So trust let us do that. Yeah, and we get a lot of flexibility in them. And some of it goes to who our beneficiaries might be. Yeah, one of the big common things I hear all the time is, I'm leaving money to someone who has a drug or alcohol issue. Okay, well, let's set up some good behavior provisions where they have to test negative and be clean for a period before they get a distribution. Or I have a beneficiary who, they for every dollar they have to spend 2 of them. We all know those people. They're constantly shopping. Well, we can put provisions in called spendthrift to protect them. Or children or beneficiaries who have special needs. There's all sorts of provisions we can put in trusts. A really common one is actually for my dad. It's named after him. We call it a speed bumps trust. And the idea actually comes from the fact that, well, anyone my sister ever dates, he's of the opinion that he should have the legal right to run them over with his car. And back over them. Because he's got to make sure he does a job right if you're going to do it. But really, what is he worried about? And what are most parents worried about? I'm going to leave money to my kid who's going to get divorced. And then the ex-spouse is going to take the money and run. That's actually, and it happens. Well, that's where trusts come in. Because we can leave those funds for that person in trust and then set it up where it can go to them, but it's not theirs. They don't actually own it. The trust does. So while they still get the benefit, they can still get the income. They can even get some of the principal. It's not in their own name. So now they have the situation of divorce. Well, there's a case in Connecticut that says you can't count on that money. So we can do a lot of things in a trust that we can't do in anything else. That's why trusts are so cool. That's why they're so important. And a big area that comes up more and more is, do you want to guess what the #1 area of fighting is today in court for trust or wills when someone passes away? It's not money. Not money anymore. It's tangible assets. Tangible property. Your purses, your phones, your glasses, your jewelry. That's all tangible property. People fight over this stuff like crazy. It's a constant state of war. And it doesn't matter if it's valuable or not. In fact, in a lot of cases, it's not. I watched these two kids recently fight over costume jewelry. It was probably worth $100. They went to war. They had hearings over it. They went to trial over who should get the stupid piece of costume jewelry. Okay, you're all getting this much money. How about you just buy one? Because it's not about the item. In a lot of cases, it's about the memories the item might hold. Or in some cases, it's just about their own relationship. And if you give people room to fight, sometimes they will. Now, there's the things they won't care about. No one cares about your furniture. No one's going to want your bedroom set. They're not going to want your dining room table, most likely. No one wants the plates from your kitchen for the most part. Forget your silverware. No one cares. That stuff, everyone leaves that stuff behind. But it's the other stuff. Photos, jewelry, even once in a while, clothing, certain clothing items can be a big deal. Those are the things people look at. And with a trust, we can start thinking about those things because we can start figuring out, okay, this is who I want to leave that stuff to. And we start listing it out. Now, the problem in the old days, you used to do that with a will. Well, then you bought something new and you had to redo the will because every time you bought something, you had to redo the will. Not so with a trust, because a trust, you can have a continual list and just constantly keep updating it because people will fight over it. And in fact, there's entire TV shows dedicated to people fighting over personal property. I don't know if anyone's ever seen the show, The Good Wife. It's terrible, but my girlfriend has an obsession with it. I'm a terrible person to watch legal shows with because that's wrong. And usually I get thrown out of the room, but they had an episode that was so bad, even I was speechless. And they did a skit about this woman died and she left this painting and apparently there were sticky notes on every personal property item in the house and whose property was it? And let's get an expert in from the sticky note company about the glue and how far it fell, if the note fell off something. And oh my God, there's a robot vacuum. Where did it pick that up? That's not how we determine property ownership at all. It's not real. Although it was funny because I did get 3 calls after it aired with people asking if it was real. No, that's not how it works. And nobody has ever called the sticky note company for a probate estate. But it is interesting that those fights are real and those issues are real of who gets it. And the sticky notes, they're not legally effective. No one has to follow them. In fact, they'll be ignored. So it's important to designate who we want to get things and do it in a writing and make sure it's done valid. Because we want to avoid those fights, those family heirlooms, photos. Photos are less of a fight today than they used to be because thanks to electronics, but even still, we still see them every once in a while. Jewelry and artwork and collectibles. All of those things are constantly at war over. So we need to do things to avoid those fights, and we want to avoid those fights. They're silly fights, and they're fights that shouldn't exist. And we really want to ensure that we're protecting ourselves and our beneficiaries when we're creating this. And that's the thing that a trust lets us do. Now, there's another side to trust, because all we've talked about so far is a revocable trust or a living trust, but the opposite flavor to it is irrevocable. And an irrevocable trust can serve a lot of purposes as well, and they're used differently. Most irrevocable trusts are for tax purposes, but they're also used a lot for asset protection. So since we already started making fun of my dad, I'm just going to keep picking on him for a while, because he's not necessarily going to have a revocable trust or living trust, but maybe he'll have an irrevocable trust. So let's say tonight I get home and he gives me a call and he says, I'm giving you my house. I'm going to say no. Why? Who turns down a free house in Connecticut, no less? Why am I turning down a house? Okay, tax purposes. At least you didn't say I was crazy. Why else? He annoys me. He gives me the house. He annoys me. Can I throw him out? Yep. Yeah, I could throw him right out of that house the next day. There's no protection for him. He hasn't thought that far ahead yet, but he would at some point. So that's not good. But what about me? Is there protection for me? Well, what happens if I'm driving home, I get into a car accident? Can they go after that house? What happens if I get sick myself and I go into long-term care? Can they go after the house? What happens if I get divorced? What happens if I die? Ooh, that's trickier because now I have to adjust my entire estate plan to let him live there. Well, that's tricky. So all the risk with doing that exists if he just gives it to me. That's why life use, that's why just transferring your house to your kids, which everyone thinks they should do, is a terrible idea. It creates a world of problems. And that's where an irrevocable trust comes in. Because we take that house and I make him put it into the irrevocable trust. I can't kick him out anymore because the trust says I can't. It says he has the right to live there for the rest of his life. Pretty simple. But I also don't have to worry about me being at risk because, oh, if they try to sue me for that car accident, well, I don't own the house. The trust does. If I get sick and go into long-term care myself, well, I don't own it. The trust does. I get divorced. She can't get it either because I don't own it. And we already know that that doesn't work. So all of the risks associated with the house are now protected by putting it into the irrevocable trust. Now, why is he trying to give me the house? Why would we even be putting it into trust to begin with? Because he's worried about long-term care costs. He's worried about going to a nursing home. Because as he gets older, his risk goes up significantly. So he wants to get it out of his name. So most people want to do. That's where the trust comes in, because the trust takes that ownership. The trust now owns the house. It's out of his name. 5 years after we moved it to the trust, it's 100% safe for Medicaid if he goes to a nursing home or he's on home care. It can be protected earlier for some of the home care benefits now. So we've created this route where he's now safe. He doesn't have to worry about losing the house for care. He's protected the value of the home, which is what he was worried about for his kids. And I've protected myself from making sure that I'm going to face problems. There's a number of other advantages by doing this. Now, the first one is you talked about taxes before. Now, I am worried about taxes. I'm not worried about the property tax. I'm not worried about gift tax because until he gives me $12.9 million, we don't have to pay that. So I'm not really worried about that, but I am worried about capital gain. Because when he gives me the property, I get it at what's called his basis, which is what he paid for it at. So when I go to sell it, the difference between what he paid and what it's worth, well, that's all gain or capital gain. And depending on how much money you make, and for most people, they fall into this, when they're younger, they're going to pay it about 20+%. Thanks, Dad. It's a big gift. But if I put it in the trust, I don't have to do that. Because during his lifetime, I get to use his personal IRS exclusion, which is $250,000 for a single person, $500,000 for married. If he passes away, it's stepped up to the value it's worth on the date of death. So either way, I've wiped out the capital gains. I don't have to worry about the taxes anymore. So the trust gives us a lot of benefit. It protects him, it protects me, it gets things out of his name. And it doesn't have to be a house. I mean, it can be a house, it can be cash, it can be stocks. There's all sorts of assets that can go into an irrevocable trust, just like a revocable trust. The difference is how it operates during our lifetime. Because with a revocable trust, I can take money out of it any day I want. I can change my investments, I can sell my house, I can do whatever has to happen. With the irrevocable trust, it's a little different. We're trying not to remove money from this trust. He can't get a check from it ever. The trust is not allowed to write a check directly to him, because if the trust writes a check directly to him, we've broken the terms, which say it's irrevocable and he's not supposed to get it. And that could make it an available asset for Medicaid. But I don't just stop there. I build in a backdoor. And the backdoor says, if he needed money out of the trust, well, there's nothing that says I can't give some to my sister. And there's nothing that says that when the money goes from the trust to my sister, that she can't then give it to dad because she's a really nice kid like that. And now he's going to get the funds back. So we get a lot of ways about doing those things. There's all sorts of setups. And that's the key with this, is coming up with the setups and how it's going to flow to the person. And a lot of this comes back to the transferring of the values of trying to protect things, but also ensure we're protecting everyone else, because he tried to protect me when I was growing up. Now it's my turn to protect him. You know, that's a value transfer. That's one of those things we have to think about. So planning lets us do that. You know, a lot of times people go, oh, I need X document. You don't need X document. You need a plan. We need to come up with what it's going to look like and figuring out the values that we want to share with it. You know, planning itself is actually a value add, because a lot of people don't realize this, but it's a huge stressor for a child not to know what to do. You know, I get this question all the time. I was just responding to a message before we started where, you know, mom's in the hospital and, oh my God, what do I do? She never told us anything. She probably did. She just didn't have it outright with you. But she did, because she talked about a neighbor down the street who was getting older and getting sick, and there were issues. And she would say things like, hey, pay it, you know, I can't believe those kids are letting mom stay home. You know, that's the key with this. It's always about having a plan. You know, it's one of my rules in life is you have to have a plan. Everyone needs one. You know, it's also a thing that people say is that, oh, it's too late to plan. That's not true. There's always a plan, just may not be the options we like, but there's always a plan. There's also no right or wrong. Yeah, I get this question all the time. Is it right to do this, or am I wrong? I had a woman who left $2 million to her dogs and $500 to each of her kids. She asked me if that was wrong. I said, well, are your dogs loyal to you? She said, oh yeah, all the time. I said, are your kids? She's like, oh, nope. Okay. Right or wrong is all in the eye of the beholder. If it's what we want to do, then it's right. And we can only do what we're comfortable with. You know, a lot of people, it's like, oh, I got to do this. Well, if you're not comfortable doing it, then maybe now is not the time, because you have to be comfortable with it. There's things you have to think about. You know, we want to avoid the hidden risk. We want to avoid any potential for conflict. And even if we've already done something, we're never done with it. You know, just like doctors, legal documents need checkups too. Yeah, it's really important. And I see this just so often these days, where documents are out of date or out of goal of what the person wants. Or I have a case right now where a brother named his sister on his power of attorney, sister named the brother as hers. Brother had a stroke, sister has dementia. Now there's no one. You know, and it's because they hadn't updated it. I talk to the family and they go, oh, they've been intending to do it forever. Well, intentions are all good, but it didn't get anywhere. It's important to just make sure and look at them and audit them and make sure are we still talking to these people? Are they still alive and healthy? I just had another one come in where they hadn't talked for 32 years. I want a person I haven't talked to for 32 years making my medical decisions. They're definitely going to know my values today. It's making sure we keep track of it. That's the key. So with that, I thank everyone for attending. We have folders up here for everyone with some information in it, and I'll stay here for some questions.